السلام عليكم ورحمة الله وبركاته. الحمد لله رب العالمين والصلاة والسلام على النبي الأمين وعلى آله وصحبه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. اللهم لا سهل إلا ما جعلته سهلا وأنت تجعل الحزن إذا شئت سهلا برحمتك يا أرحم الراحمين آمين يا رب العالمين. Dear brothers and sisters, inshallah, today I'll talk on Sharia Supervisory Board. So I'll talk about what is Sharia supervision and the duties, the roles that the Sharia board that they play, and as well as what are the roles and responsibilities of the financial institutions towards its Sharia Supervisory Board, and what are the qualifications to be a member of the Sharia Supervisory Board, and some of the issues and important factors related to Sharia supervision, inshallah. So, what is Sharia supervision? According to Karim, Sharia supervision is ensuring the extent to which the operations of the Islamic financial institution, means the company or bank, they conform to the provisions of Islamic law and with the accordance of the fatwas issued and the decisions approved by the fatwa authority. So Sharia supervision is just to make sure to supervise, to oversee, to monitor whether the financial institutions, either is a bank or is a takaful institution, whether they follow the principles of the Sharia or the fatwa issued by the um, National Fatwa Council, or even the fatwa issued by the Sharia Committee, whether those fatwas are followed or not. And so they will oversee, and also the Sharia supervisors or Sharia Supervisory Board, they also give assurance on the Sharia compliancy of the financial institution. So we'll know more detail of what is their job scope and what are their roles and responsibilities in the following slides, inshallah. So now I'll talk on the Sharia supervision from the Malaysian perspective. As the last lecture, I showed the Sharia overall, the Sharia governance model in Malaysia. So in Malaysia, there are two levels of Sharia supervision. The first is we call the Sharia Committee that will sit in every financial institution. Like every Islamic bank, they will have a Sharia Committee. That Sharia Committee will oversee and monitor and supervise that Islamic bank. And then there is another Sharia supervision at the national level that is called the Sharia Advisory Council of Bank Negara Malaysia, that is under the Central Bank of Malaysia. So these are the two levels of Sharia supervision in Malaysia. So now first I'll talk on the Sharia Committee and their roles and functions, what they should do. So among their roles and duties is of course to advise. That's why they some are called the Sharia Advisory Council in some time. So well, there are different names in different countries. Some called Sharia Committee, some called Sharia Advisory Council, some called Sharia Supervisory Board, some called Sharia Advisory Board. However, in Malaysia, they use a specific term, like these two specific term. One is Sharia Committee, that means the Sharia Supervisory Board in the respected Islamic financial institution, and a Sharia Advisory Council or SAC, that means the Sharia Supervisory Board at the national level that sits in the Bank Negara or the central bank of the country. So for the Sharia committee, their main duty is to advise the board of the directors of the Islamic financial institutions on matters in its business operations. So in the overall, in terms of policy makings and the business operations, they will advise the board of the directors on the maqasid sharia and others, as well as the principles of muamalat. And second, to endorse the Sharia compliance manuals. So it is the responsibility of all the financial institution to prepare the Sharia compliance manual. So this is a manual that will give the details on how what are the procedures and arrangement or practices to get the Sharia opinion and how to implement them. So so this manual will give details on the process of getting fatwa or Sharia opinion from the Sharia committee and the procedures to implement those fatwa or the resolution issued by the Sharia committee. So that manual should be endorsed or it should be validated by the Sharia committee. And third, to endorse and validate relevant documents, example, the terms and conditions of the products and documents. So all the products and documents that all the products that Islamic financial institutions they offer, it has underlying contracts, it has terms and conditions, so it should be validated, means and should be endorsed. So by the Sharia committee. So the Sharia committee should see all those, go through all those terms and conditions, and some of those are very long, it can be few hundred pages. So they need to go through all those terms and conditions of the product, and they need to validate and endorse the whether they are in line with the Sharia or not. And then number four, to assist related parties on Sharia matters upon request. So if any department or any organ of that financial institution, if they need any help related to Sharia, for example, if the product development department or the risk management department or even the marketing department or the treasury, if they need any assistance in terms of Sharia opinions, so that it is their responsibility to give advice them on Sharia matters. And then to advise on matters to be referred to Sharia Advisory Council of Bank Negara Malaysia. So this Sharia committee will work together with the Central Sharia Advisory Council, or what we call the Bank Negara Sharia Advisory Council, that we call SSC. So any matter that this Sharia committee in that respected bank, if they cannot solve or if there is a new issue that requires a new fatwa or new resolution on that, so they should refer it to the National Sharia Advisory Council, and the Sharia Committee will be responsible for that, and they will decide what matter should be referred to the Sharia Advisory Council of Bank Negara Malaysia. And then it is also their duty to provide a written Sharia opinion, particularly when the committee refers to SAC, and whether the Islamic financial institutions submit applications to Bank Negara for new product approval. So along with deciding on the matters that should be referred to the SAC, and also if there is a new product, the financial institution needs to get approval from the Sharia Advisory Council of Bank Negara Malaysia. So in that case, the Sharia committee also can give their own opinion first, that the Sharia committee view that this product is Sharia compliant, therefore they allow this product, and then they will forward it to the Sharia Advisory Council of Bank Negara. So it will work that way. So it will help the Sharia Advisory Council of Bank Negara to give a resolution on that, and they will give a written opinion. And finally, to assist the Sharia Advisory Council of Bank Negara on reference for advice. So they will work together with the Sharia Advisory Council of Bank Negara. And if the Sharia Advisory Council, they refer back to the Sharia Committee on further clarification on the operation of the product, so they will work together and they will work as a reference um, for the um, for getting advice for the banks as well. And this is the Sharia Committee's report. This is also the job of the Sharia Committee, and each Islamic financial institution they are required to publish their Sharia Committee's report at the end of the year, usually in the annual report. So in this annual, this is a sample copy of an annual report where the Sharia Committee or the chairman of the Sharia Committee will sign on behalf of all the members of the Sharia committee. So here they will tell that based on their observation, their assessment for the last financial year, there was no violation of the Sharia, and if there was any non-halal income due to the violation of the Sharia or because of some um, unavoidable reasons. So they have purified the asset, the non-halal income, and also the calculation of the zakat is made and is provided. So this is the annual certification and assurance to the shareholders as well as all the stakeholders on the Sharia compliancy of the financial institutions. So actually, it shows that ultimately the Sharia committee they are responsible on the financial on the um, compliancy on the Sharia compliancy of the financial institutions, and they have mostly fiduciary duty. They have a great trust on this, especially from Sharia perspective. Now, with the duties of the Sharia Committee, there are also duties and responsibilities of the financial institutions towards its Sharia Committee. They also must provide the platform and some other facilities for the Sharia Committee to do their work. First, they need to refer to all Sharia issues to the Sharia Committee because Sharia Committee may not know certain Sharia issues, so it is the job of the management of the financial institution to refer the issues to the Sharia Committee. And whatever the Sharia Committee gives advice, it is their responsibility to adopt and to implement the advice of the Sharia Committee. And then to ensure the product documents are validated. So it is also the responsibility of the financial institutions to submit the product documents, the terms and conditions to the Sharia committee and then get their approval. And also to prepare the Sharia compliance manual. As I said, the Sharia compliance manual will include the procedures to get Sharia opinion, to the procedures to implement, as well as to disseminate the Sharia resolution. So this compliance should be prepared by the financial institution and it should be validated by the Sharia committee. And financial institutions should provide access to all relevant documents to the Sharia committee if they need further details on any of the products, they want to check on any financial documents, so the Islamic financial institution should provide. And along with the documents, they also should provide sufficient resources in order for the Sharia committee to do their meetings and to meet or even to do their research and also um, um, in order to check on certain operations. So Islamic financial institutions should provide all the resources. And finally, they also should remunerate the Sharia committee accordingly. We'll discuss who will decide their salary, but usually it is by the shareholders, but financial institutions will provide the salary. Now, some important aspects of Sharia committee's function in order to function at uh, at its best, there are some factors that need to point out how the Sharia committee can um, operate at its maximum. first to include someone with expertise in accounting. As we know, that Islamic financial matters, the products, they may include some issues that the Sharia experts who are only expert in Sharia, they may overlook on certain financial issues that actually is a very important issue. Or sometimes when the management, those who have financial background, they when they present, they may hide certain information that may be an issue from Sharia perspective. So in order to overcome that issue, they need to include someone with an expertise in accounting, or maybe from finance, or even from a law background. So it will strengthen the composition, so that it will help the Sharia advisors to be more prudent, and as well as they can be able to find out, look for issues on accounting or financial matters. And SC should meet with audit committee and or external auditor to review the financial statement. Well, generally in Malaysia, the internal audit, they will report to the management, and as well as the Sharia committee. However, maybe mm, there can be some gap when the internal auditors, they report to the management first, and then later they report to the Sharia committee. So there may have been some gaps. So in order to get further assurance, it is better that the Sharia committee also will work together with the audit committee, the board audit committee, as well as with the external reviewer. So the external reviewer will give further confidence to the Sharia committee on whether there is any violation on the application of the Sharia or the financial transactions. And then disclosure of details of the activities of the Sharia committee, the number of board meetings, etc. So this is very important in order to get confidence for the shareholders that the Sharia board, they are also active, they have done their job well, or they have been doing their duties accordingly. So it is better if they disclose the meeting number, where the meeting was done, and what was the decisions, and what the reasons or justifications for the decisions taken. So if they disclose, and if they actually publish, as many researchers and also the public, they actually want to know what is the Sharia rulings for this, and what is their opinion on that. So it is better if the financial institutions also, they disclose the activities of the Sharia committee, as well as their resolutions, what resolution has been made on a certain Sharia issue, that will give further confidence to the depositors as well as the shareholders. And then the number of attendance is security as Sharia committee meetings should be at least 75%. Well, this attendance in the meeting is quite important, because if a Sharia committee misses one meeting, he may have missed one important Sharia issue, and which may have disagreed with others. So if someone is absent is more than 25%, that may trigger confusion and also can have an issue. So we need to assure that there is a attendance of at least 75%. And the Sharia committee should be an independent body. So the Sharia committee should not be a full-time, the members should not be the full-time members. So similar to the board of the directors, so they also work as a board. So they will be mostly independent members. Usually they are lecturers or researchers in Islamic finance, or religious authority in different institutions, and they sit in the Sharia board. So if they are the employees, so that may cause an issue of their independency, whether they can take whether they are independent to take any opinion, or there is an influence from the management or even from the board of the directors to give their Sharia opinion. So here, the Bank Negara Malaysia is also quite concerned on the independency of the Sharia Committee, and also any kind of influence, or we can say undue influence, that in a indirect way or in certain way to influence the Sharia Committee to to persuade to them to take one opinion. So that quite Bank Negara is has a guideline on that, and it says the board, means the board of the directors, shall recognize the independence of the Sharia Committee and ensure that the committee is free from any undue influence that would hamper the Sharia Committee from exercising objective judgment in deliberating issues brought before them. So it is the responsibility of the board of the directors to make sure the Sharia committee is free from any direct or indirect influence from the management. Correspondingly, the Sharia committee is expected to make sound decisions on Sharia matters in an independent and objective manner. So at the same time, it is also a duty, it's a fiduciary duty, it is a trust, and it is an amanah of the Sharia committee members, that they also, when they give their judgment, they will be fair and they will not be biased, and they will act based on what they find, what is truth and what is right. So now, the legal position of Sharia committee is quite important, as what is the good thing in the Malaysian jurisdiction is that while a number of countries they do not have an act that forces the financial institutions to comply with the Sharia. But in the Malaysian Islamic Financial Services Act 2013, it requires and it gives a deterrent punishment if any financial institution violates any Sharia principle, if they do not, and if there is a violation, if they do not immediately report it. So this is an extract from the law. So the law generally said, if the violation may have happened, but if there is a violation, the financial institution should report immediately, and then they should report to the Sharia committee, and whatever the Sharia committee gives advice, or even the Sharia Advisory Council gives advice, they should follow. But if they do not do so, if they do not report the violation, the Sharia non-compliancy events, so in that case, there is a severe punishment. As you can see, a person who contravenes section 103, means regarding to the violation of the Sharia principles, commits an offense and shall on conviction be liable to imprisonment for a term not exceeding 8 years, or to a fine not exceeding 25 million ringgit or both. So this is a severe punishment, and this punishment can be given to the financial institution or even to the respected employee. As I have known, there are some cases in Malaysia where certain banks, they have been penalized a big amount of money because of the violation of this act. Now, let us look at the qualification of the members of the Sharia committee. Who is eligible to be a Sharia committee? So, of course, we know that they should be the Sharia scholars. Generally, we understood, and they should have the ability to ascertain laws for certain financial issues. So here are the four important aspects of the qualification. First, a member of a Sharia committee shall be a Muslim individual. A company, institution, or body shall not constitute a Sharia committee. So under the Bank Negara, for the Islamic banks and takaful institutions, the Sharia advisor should be a person, while under the Securities Commission, like for Sukuk or for um, um, uh, other financial in institutions like for Sharia compliancy of the company shares. For that, an institution can be a Sharia advisor. But for Islamic banks and takaful institutions, the Sharia advisor should be a human being and he should be a Muslim, because based on the, of course, the non-Muslims, they can learn the law, but in order to give a fatwa, it is the required condition of the Sharia that he should be a Muslim. And so that is the first condition. The second, the majority of members in the Sharia committee shall at least hold bachelor's degree in Sharia. So, well, there might be one or two. Usually in Malaysia, the composition of a Sharia committee is five or six. So usually there are one or two from law or finance background, but the majority of them means at least three in five should be holding the degree in Sharia. So Sharia means those who are specialized in the understanding Islamic jurisprudence, the fiqh muamalat, Islamic law for financial transactions, and also they know the maqasid sharia, the usul al-fiqh, the principles of Islamic jurisprudence, and the how and the istihad and related principles of the sharia. So they should be the majority. Well, here one important thing to mention that there are some Islamic banks, they sometimes put some religious big figures, like who is a good da'i, or but they are not in Sharia. Well, you see, in Islamic disciplines, there are like Usuluddin and Da'wah, or there are Quran or Sunnah. So some of the scholars, they are specialized on that, but they might not be specialized in Sharia, especially in the modern day where there are specialization where uh, people are specializing in only one field. So in that case, the Sharia committee members, those who are specialized in Sharia or fiqh and usul fiqh, they should be in the Sharia committee, rather than those who are big Islamic figures, but their specialization maybe in, for example, in da'wah. They are actually not recommended to be in the Sharia committee. And then for Malaysia, number three is for Malaysian perspective, the strong proficiency in Arabic, Bahasa Malaysia, and English. So for Malaysian regulator, once those who are in the Sharia committee, they must be well versed in Arabic, English, as well as Malaysia. So those, so maybe it restricts the those who do not know Bahasa Malaysia, they may not be able to sit in the mm, Sharia committee. And that's maybe because there are many products and their terms and conditions in Bahasa Malaysia. However, generally in Malaysia before, and there are some Sharia scholars, especially from Middle East, they also sit in the Sharia committee of some Islamic banks. Um, but with this requirement, maybe it will be difficult in the future. Number four is may comprise experts from relevant backgrounds such as finance and law. Yes, for their in order to perform better. However, even they still need to. They should not be the majority. They just do to help the Sharia committee. And in terms of the presentation of the committee's opinion, uh, they must, in order to ensure the freedom of opinion of the Sharia committee, there are some conditions. One, they must not be working as personnel in the bank, as I mentioned before. The Sharia committee should not be, the members should not be the employee in order for them to speak freely, and then they should be appointed by the General Assembly, means they should be appointed by the shareholders. However, in the case of Malaysia, they are appointed by the central bank, uh, and the Islamic financial institution will propose, they will offer the names, and the central bank will appoint them. So that also puts some kind of doubts, well, because the proposal is made by the Islamic financial institution. So that is the one way, and then other way, which is recommended by the AOFI as well, is it should be appointed by the General Assembly, means by the shareholders. The shareholders will appoint the Sharia committee members. So that will be so that they will be more independent. They can work together with the board of the directors. And number three is the General Assembly fixes their remuneration, yes, so that there is also no influence by the management of the IFI. If the salary is fixed by the shareholders, so the Sharia committees, they will not be influenced by the management of getting lower or higher salary. Number four, it should have means and jurisdictions as the auditors of accounts. So the Sharia committee should have the authority to be the auditors, so that they can also audit, and they can check whether there is any violation in terms of the financial transactions or in the financial statements. So they should have that kind of the power authority to do that. Now, there is one issue in the Sharia committee or Sharia supervision, is the differences of opinion. As we know, the differences of opinion are there among the scholars, among the fuqaha, and it is considered as rahmah, is a mercy, because it gives us more options and it gives us choice to apply based on different situations. And also the differences of opinions are due to catering different needs and situations. The differences of opinions are there. However, um, when there are too many differences, it can also have create some problems, especially in when in from the legal perspective, because when we want to make anything legal or illegal, so we must need certainty. So in that case, we need to harmonize the differences of opinion, or the Sharia committee members, they should come to one conclusion based after the discussion, or maybe the chairman should take the opinion on behalf of the members when they cannot agree on something. So so the fatwa of even one committee may differ from another, and also we can see even in one country, even in Malaysia, one Islamic bank allows this product, but another Islamic bank does not allow. So there are differences of opinion based on the Sharia scholars, their understanding, and based on also their research and their ijtihad on that issue. And so this unification of the opinion is crucial, and so sometimes it really creates a problem, and especially as we know in the case of Malaysia overall, when they allow certain contracts like bai'ul ina or bai'ud dain, so it creates some issue or doubt to the foreign investors who mostly they follow the different opinion, so they are reluctant to invest or to deposit money in that Islamic financial institution. So from that perspective, it is very important to harmonize at least, or to codify the Islamic laws. So first, from the perspective of the law and governance perspective, we need to harmonize. And second, in order to reduce or in order to gain the confidence of the investors, we need to do codification. And we can see in the Islamic history, like the Ottoman, they did codify their laws, and of course it is not possible to force everyone to follow the same rules, but at least in a given country or in a given jurisdiction, the scholars can sit together. While in the case of like Malaysia, where there is a national Sharia Advisory Council, so they may resolve a certain issue in order to uh, reduce the differences. So with that Sharia committee, there is the Sharia Advisory Council of Bank Negara. So this is the Sharia Advisory Council that has the highest Sharia authority in Islamic finance in Malaysia. Even any Islamic cases or Islamic issues is brought to the court, the judge should refer to the resolution issued by the Sharia Advisory Council of Bank Negara, which is mandatory for the judges. So regarding to financial issues, Islamic financial issues, the highest authority to give any decision is actually the Sharia Advisory Council of Bank Negara Malaysia. And this thing happened when actually there was a disagreement if, a few years ago, I think around 2010 or 8, where the Sharia Advisory Council allowed uh, BBA, and then the High Court judge disallowed it, so it triggered confusion. And then the Central Bank Act 2009, it gave the Sharia Advisory Council the highest authority to decide on any Sharia matters in financial transactions. So this Sharia Advisory Council also responsible for validating all Islamic banking and takaful products to ensure their capability with the Sharia principles. So if there is a new product in any Islamic bank, so the Islamic bank need to refer to the Sharia Advisory Council for their approval. Of course, the Sharia committee will work together with the Sharia Advisory Council, but final approval should be uh, taken from the Sharia Advisory Council of Bank Negara for any new product. And also this SAC also advises the BNM on any Sharia issues relating to Islamic financial business related to policy making, and also any other products, and also in terms of developing the standards and regulations. So this is the SAC resolution. So they published their resolution in a book, and which is it's a PDF book, is available. And also they have also resolution published in Bank Negara's website. So they are actually the reference for whether something allowed in Malaysian Islamic bank, finance or not. It is actually, this book is the reference book. So I would recommend all the researchers who do research on whether uh, on the Sharia permissibility or Sharia issues related to products and services, they should refer to the Bank Negara's Sharia Advisory Council's resolution. So this is the primary source to know whether something is allowed in Islamic financial institutions in Malaysia or not. So and it is easily available to get. So in 2019, the Bank Negara Malaysia, in order to enhance their Sharia supervision, they have also added some extra resolution, and also they have removed some of the requirements that was just that was not needed, or that was just it was just a kind of repetition. So these are the latest guideline, that is the additional guideline that adds to the previous one, which was issued in 2011. So the latest guideline restricts the tenure of a Sharia committee members to a maximum of 9 years in a single Islamic financial institution. So this might be done for maybe two reasons that I believe. Of course, there is no reason for that they mention, but what I believe is that first, when one Sharia committee member is sitting in a financial institution for too long, so it may create a kind of relationship or bonding with the management, and that may lead to some kind of undue influence on the Sharia committee. First, and second is if if one group of senior Sharia committee members they are sitting too long, so it may also restrict or it may the newcomers to enter the industry. So there, it is as we know in Islamic finance there is a scarcity of Sharia scholars and Sharia committee members, and there are only a few senior scholars. They are leading the industry and they are taking they're sitting in many number of boards. So if someone is sitting for a long time, so it may be a barrier for the new Sharia scholars to sit and to also to practice their Sharia opinions. And then the second resolution is that banks should notify the BNM about any additional restrictions that go beyond the SAC rulings. So this one is actually to minimize the differences of opinion. So whatever the Bank Negara Sharia Advisory Council approve, if the certain bank they want to disallow it, they must inform the Bank Negara Sharia Advisory Council so that there is no misunderstanding among the public or there's no doubt among the public. So means if this is in if any Islamic bank wants to make any additional restriction, and then it prohibits active politicians from becoming Sharia committee members. So that might be as well a very important ruling. While sometimes when politicians they sit in a Sharia committee, so because of the politics, they also may be influenced by that to give opinion. While some of the politicians they may uh, they may consider the interests of his political party, or maybe so when he is giving his Sharia opinion. So in order to stop that, the Bank Negara has stopped any active politicians to be Sharia committee members. And another important thing in the latest guideline is that the uh, the Sharia board, and the Sharia committee, and the board of the directors, they should have a healthy communication. They have a better and effective communication in order uh, to remove the non-compliancy or non-compliancy risk. So this is the Bank Negara recommends that the Sharia committee should work together with the board, and the board also should create procedures so that they can have a effective communication with the Sharia committee on matters related to fulfilling the Sharia and Sharia governance, and also Sharia non-compliance risks. So this is so the board of the directors they may can have maybe a meeting, for example, in together with the Sharia committee at regular intervals, so that they can share their ideas or what the issues that can be resolved together. So that is actually a better way to solve the problem before it happens. And finally, removes the requirement of Sharia review and Sharia research function, which is to be conducted by a qualified Sharia officer. In the 2011 guideline, all the Islamic financial institutions were required to hire a Sharia officer, a Sharia officer to conduct Sharia research and also to do Sharia review. However, it sometimes felt that it is just overlapping, and it is also a burden to hire so many Sharia officers to do Sharia audit, Sharia review, Sharia research, and others. So now it is required for the bank overall to do research. So it will be done by the all and also to the research department, and also yeah, by the Sharia committees. So there is no requirement to hire a Sharia officer to do Sharia research, and similarly to do Sharia review. So there will be now only Sharia audit. So there is no requirement of Sharia review. under this latest guideline, probably because they merge with the Sharia audit. So there are very little difference between Sharia audit and Sharia review, while actually the Sharia audit can cover the Sharia review as well. So that maybe because of the overlapping, or because also the confusion, because in the industry people, they are not sure what is the job of Sharia audit, what is the job of Sharia review. So because of that confusion, the Bank Negara has removed the requirement to have a Sharia review. So both the Sharia review and Sharia audit will be done by the Sharia audit department, or maybe the Sharia risk department. So that is all about the Sharia supervision. So in Malaysia, they have two layer of Sharia supervision, one at the Sharia Committee, and at the another one at the national Sharia level, which is Sharia Advisory Council of Bank Negara Malaysia. So these two layer actually to ensure the Sharia compliancy and to give confidence. And these Sharia advisors, they are actually doing the fiduciary duty. They have a trust. At the same time, the financial institution also needs to cooperate. And well, there are many issues in Sharia supervision. Okay, in terms of the lack of, in terms of the scarcity of the Sharia scholars, or sometimes sitting one person in many. But while in Malaysia, the Bank Negara already restricted that one Sharia advisor can sit on only one industry, mean one Islamic bank and one takaful company only in the country. So that was one of the way to solve the problem. So there are issues, but the steps have been taken by the regulator to improve the situation. So with that, I thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.